Friends, before we go to the next slide, just keep in mind that normally if you are a corporate counsel or if you are a consultant or if you are a businessman, when you want to enter into a contract with an international party, while deciding the seat of arbitration, what all will come in your mind, or what are the points you have to keep it in your mind? Because only within that framework we can try to convince you that whether India can fit into that requirement what you are looking for. So to help you out, I am just showing a slide. Normally what we will see is what is the arbitration law of the seat. Whether it is a law which is recommended by UNCITRAL, like a model law, almost like that at least. If it is like that, then we can easily understand, because 100 and more countries, 100 and odd countries are following the same, almost same pattern of UNCITRAL law. So this will be one point. Number two is what kind of a court interference happens in that seat. Seat means that place, means Singapore or Hong Kong, Delhi or London, whatever you choose. So you will be looking at that, whether the courts will be interfering frequently, which will delay the process or not. This can be another consideration. The third consideration can be the geographical location. A parties between South American, North American continents, they will not try to choose Singapore or Tokyo as a seat of arbitration. They will like to choose a place which is closer to them. Then the fourth point can be the strength and modernization or updation of the arbitral center, what they are going to choose. Some arbitral centers are very fast in adapting to the new requirements. For example, now you may be aware that fast-track arbitrations are in practice and emergency arbitrators are being appointed. These are all happening in some arbitral institutions. Next one can be the approach of the courts while challenging. Because whenever you choose the seat of the arbitration, the supervisory courts are the courts in that jurisdiction. So how those courts are treating, whether they respect the arbitral award's finality or they try to poke their nose into every single detail. Because all of us know very well that arbitration is a process in which both the parties decide to agree on a non-statutory person to decide the issue. He need not be a legal expert. He can be a subject expert. He can be a technical expert. So if he decides, the finality should be respected, whether the courts follow that. Then enforceability issues. Finally, an award comes. It should be enforceable in country A and country B also. For example, you take a situation 2010. There is a party from China and India. They are entering into a contract. Can they choose the China center as the seat or Hong Kong center as a seat? They cannot. Because India never recognized China awards or Hong Kong awards till 2012. So you have to keep that also in mind, that where this award may be enforced, whether this jurisdiction and that jurisdiction is recognizing each other, even though they may be New York Convention signatories, but they need not recognize each other. So that is another point. Then cost of arbitration, of course, you know very well, the cost of arbitration in all these popular centers are very, very high. Even I have put in my report that if you take Singapore Arbitration Center for a 10 crore claim, your fees will be somewhere around, arbitral institution fees will be somewhere around 42 lakhs. So it's a big money. Then language of the people. Normal speaking language, communication language of the people, that also matters a lot, because a French speaking party will like to choose a French center. Normally the places where predominantly in the cities English speaking people are there, we like to go there. So these are the broad points on which a party will take a decision whether to choose this seat or not. Now where India stands. Our strong points, first let us see the strong points. Many Indians can easily communicate in English, at least in cities. So it is a very big selling point for us. The second is, India is a signatory to New York Convention, and you all know very well that once New York Convention and both the parties are recognizing our awards, Indian awards. For this subject, that is enough. Indian awards are enforceable in more than 100 countries. So it is again point number 2, which is a very strong point. Point number 3, India is in a very strategical location. Because traveling, we always say, where are you? I am just overnight from Delhi. So it's like overnight from Europe also, overnight from anywhere in Asia. So we are in a real strategical geographical point. So we can really get clients from Europe also and Asia also. Next one is, there are very good number of good English speaking lawyers in India and with lot of international exposure and even paralegals also. In our places, we have nowhere else you can see such good stenographers and people who can have a good command over English and legal languages. So less expensive litigation. Whenever there is an arbitration, there will be some consequential or incidental litigation along with that. So India is a very, very, we can say less expensive place for having such indications. So these are the strong points, we can say about 6 points, which predominantly cover all the important things, but where we require the improvement. One is the arbitration centers have to be really professionally managed. At the same time, don't ask me a question or all the popular arbitration centers are so professional that also we cannot say they are not. Many times for expecting the payment to come, they keep adjourning the arbitration hearings indefinitely. I have seen in some cases 1.5 years has gone, the party has not paid the fees, but they are giving grace time for 1.5 years. So they are not also professional, but to attract the attention of the people, we should have professionally managed, well-equipped arbitration institutions. Today, another challenge is, today an international award passed with the seat in India is treated like a domestic award. It is not given the so-called respect of the international award. So again the challenge by way of Section 34 arises. So what happens? That leads into a longer route of litigation. Now all of you are aware that some of the recent judgments in Geo case and ONGC case and all has further confused and expanded the scope of Section 34, which Law Commission has given a recommendation to the Ministry to restrict the interpretation under Section 34. We hope our Minister has committed, so I think he will be able to do that to reduce the scope of challenge under Section 34. And the foreign seated arbitrations are getting a better treatment in India because they are coming here only for enforcement. So there people think that, oh, they get a better, so I will go to Singapore and get the award. When international arbitration award is challenged in places like London, Singapore, Hong Kong, the chances of court interference is very, very, very less. Even sometimes in one of the cases recently, waiver of an arbitration clause. Normally we all know one party by going to a court, instead of using an arbitration provision, can waive off its rights. But Hong Kong says no, only both can waive off its rights, otherwise you have to go to arbitration. It's like they are so proactive towards the arbitration mechanism. So people love to go there so that there will be no unnecessary interference, because once interference is there, then appeals come, time runs like anything. Then what is the other point of improvement is statutory guarantee to allow foreign lawyers to practice in the international arbitration area at least. Singapore allows. We also cannot stop, but when it is an Indian seat, there are difficulties. Supervisory courts should be only high courts. You are aware that there will be a 3-member arbitration panel, maybe all 3 Supreme Court judges. Finally, if the party is from Orissa, he will go and challenge it in Orissa Bhubaneswar District Court. So the time, so district court judge, he will just admit, and he will keep it in cold storage for another 2 years. So your execution process gets fully lost. So this issue has to be seen. That also is a part of the Law Commission report. So this will help if it comes into this thing. a statutory provision fixing limit to have regular procedure of arbitration and expedited procedure. There are some countries who say that, okay, less than 1 crore, you cannot examine witnesses, you have to produce all your documents within 3 months, award has to be given. In many cases it can happen. Infrastructure arbitration, if you see, absolutely examining witnesses is a waste of time. But normally we do and waste time, and finally our entire argument will be only on the basis of the documents. So certain limits can be fixed statutorily to reduce the full-fledged arbitration and expedited or speedy arbitration procedure. And the last point is, we should always, people say that we should think creative or something different. So this idea may look funny for some of you, but still I want to put it. Friends, let us take an example of Dubai Financial Center. Some of you must have heard about it. They have established a court. That court practices all important jurisdictions laws. They practice English law, they practice American law, they practice even Indian law, anything. The judges are from different countries. The Partnership Act is different. If you are having your office or business in that district is like a global place. So even in India we can think one day, maybe in the direct control of Supreme Court, there can be one area which can be called as an arbitration hub, where there will be a court, supervising court also is inside. If an award comes today, tomorrow within 15 days you have to challenge, within 15 days the challenge procedure has to be completed, within 1 month the award is ready for enforcement. The whole process can be finished within 1 year. If we can create, it is possible, India will be a hub. You may ask questions, no, there will be so many legal constitutional problems. Legal constitutional things are only to help us. If it is not helping us, it has to be amended through the proper course of action. Thank you so much for the opportunity. All the best.